estate specialization provider. Barry Levine for Northern Trust for the CFP organization. Just a couple heads up. Our June 4th meeting, always the first Tuesday. We've got Thomas Pulowski, JD, Senior National Director of Trust and Estate Planning at Bernstein Private Wealth Management. Looking forward to his presentation on the current state of the economy and its impact on the current estate planning opportunities. A heads up, we're going to have a social event on May 30th at Urban in One Paseo. We're going to be putting that on with Paul Hines and Ashley Oliveira and the Aspirient Family Office. That'll be from 4 to 7 and more details to come. Other upcoming meetings and presentations you want to be aware of. May 16th is the Rady Children's Hospital Professional Symposium. An always great presentation. Robert Kirkland this year on transferring wealth to the middle rich. Tom Rogerson, a good friend of the council. Legacy planning is different than traditional estate planning. And then we're going to have a presentation by a Rady doctor on integrated mental health initiative. May 30th, a social event here in Delmar. July 2nd, we're going to have a meeting with Robert Valera of Voight Real Estate with one of his clients on their real estate story. July 29th to August 1st is the Purposeful Planning Institute's annual conference that they call Rendezvous. This is a group of folks that deal with the people side of planning, and certainly reach out to me if you'd like to know more. We have certainly other events in the latter half of the year. We'll go over those later. Certainly want to bring Pete Tentler up or wherever he may be. He's going to tell you about our trifectas. Great networking opportunity, and Pete is the man.
Thank you, Bill. Appreciate it. For those of you who are new or visiting for the first time, we created the trifecta. The trifecta is, put your business card in here. I'm going to do my best to pair you up with 2 other people that hopefully are going to complement what you do in your industry, and then get together for breakfast, coffee, lunch, happy hour, or a hike, and really just get to know each other on a more personal and business level. If you have any questions about the trifecta, just give me a call. My name is Pete Tentler. Thank you, Bill.
And sponsoring today's meeting is Aspirient Wealth, Paul Hines, Karen Clapp, and Sandra Connors, and a number of other folks that they will introduce here from Aspirient, and we're thrilled to have all of them here. Karen Clapp is going to do the sponsorship piece.
Good morning. My name is Karen Clapp, and I am a Director of Wealth Management with Aspirient. I'm joined here today by my colleagues, Paul Hines, can stand up, Sandra Connors, Mark Petrie, Linda Kitchens, Ami Arana, Wendy Wildy, Laura Mertz, and Chelsea Wong. Got the whole army here. Over the course of my career, I've had the opportunity to work in several large brokerage firms, as well as with a small independent wealth management firm. And I found that Aspirient combines the best qualities of both, with the resources and scale to provide the highest level of services while maintaining personalization and a commitment to do what's in the client's best interest. Next slide. Yes.
Was built to offer our clients personal attention and expert guidance. Aspirient was formed really out of necessity. During the 90s, a lot of the families that I served, family-owned businesses, sold their businesses. Most of them had needs where there was no other solution in the marketplace. And no organizations that had all of the resources that these families needed, they needed somebody on their side of the table to help them make the decisions in terms of wealth management. Understood their goals and objectives, their dreams, their fears. So what if there was an organization that was national in reach, was 100% employee owned, completely independent, objective advice, and had all the resources that were necessary to help these families make good decisions? How powerful would that be?
Rather than ownership being concentrated with just a few individuals, of our 200 employees here, almost a third of those are currently partners in this firm. That's huge.
Our partners, they believe in this business. They've invested in it, both in their day, with coming to work and serving clients, but also in buying in the shares. They weren't given this equity. They weren't granted stock options. They believe.
We are committed to staying permanently independent so that we are always sitting on the same side of the table as our clients.
At Experian, we choose to work as one unified team, which is very different than many other organizations. The comprehensive advice, it requires a diversity of talents coming together as one unified team to create the outcome. Will be terrible for a long time. What we're doing, trusting us with their hopes and dreams, and that's really a big part of our story. Make sure that there's an alignment of values. Do I like the people? Do I connect with the people?
Next slide, please. Oh, there's a PowerPoint. Okay, I'll move along. Experian is a leading national independent employee-owned wealth management firm. We have $14 billion in assets under management and 10 offices across the country. We have 230 employees, 8 of which you see here today, many of whom are CPAs, JDs, CFPs, and CFAs, and more than 80 of whom are partners in the firm. Experian has 3 practice areas. We have total wealth management, where we provide wealth planning and investment management for clients with $2 million of investments and more. Our clients usually include corporate executives, business owners, professionals, and affluent families. We also have an exclusive family office for clients with $30 million or more who require more comprehensive services, such as tax, estate, and strategic philanthropic planning, investment management, including private investments, generational succession planning, and bill pay and expense management. Finally, we have a professional fiduciary practice where we serve licensed fiduciaries who serve as trustees, conservators, guardians, agents, and executors for other people. Experian is held to the same fiduciary standard of care as the trustees that we serve. We provide investment management that complies with the Uniform Prudent Investor Act. We leverage our relationship with our custodians to help marshal assets and provide back office support. And finally, we aggregate all of the fiduciary's client matters for fee purposes to help lower the fee across all of their clients. Experian is a proud sponsor of the Professional Fiduciary Association of California and also the Independent Trustee Alliance, both of whom are excellent organizations. Next slide, please. Keep going. Next slide. One of the total wealth management clients we are working with is the trustee and income beneficiary of a $15 million irrevocable trust. The trust remainder beneficiaries are the client's adult children. The trust was created in the 90s, and because stocks have grown over time and the portfolio was never rebalanced, The trust's current asset allocation is 80% stocks and only 20% in bonds. So there's now $8 million of unrealized capital gain in the portfolio. Great. The trust only generates 1.25% in dividends and interest, and the client came to us with a cash flow problem in search of more income. Next slide, please. Now, unwary advisors might suggest reallocating the portfolio to produce more income. For example, if we wanted to reallocate to a 50% stock, 50% bond portfolio, this would require selling $4.5 million of stock and reinvesting in bonds. We would then realize $3 million in capital gains, which is taxed at the trust level. At trust tax rates, this would result in 20% federal capital gains tax, another 3.8% in net investment income tax, as well as 13.3% state income tax. So terrible result, over $1 million in taxes. Fortunately, in January of 2024 of this year, California became the 7th state to enact the Uniform Fiduciary and Principal Act. And among other things, the act allows a trustee to convert an income trust to a uni-trust if the fiduciary determines the exercise of the power will assist the fiduciary in administering the trust or estate impartially. That means balancing the interests of both the income and remainder beneficiaries. Under the act, the uni-trust rate may not be less than 3% or greater than 5% without court approval. Next slide, please. With a uni-trust, the amount distributed to the income beneficiary is expressed as a percentage of the net value of the trust assets each year. Instead of trying to maximize the income on the portfolio, which would be to the detriment of the remainder beneficiaries, we could focus on total return investing. That is the combined return from income and the growth of principal. In our example, a 3% uni-trust would increase the payout to the income beneficiary by $263,000. Now, uni-trusts are not for everyone. Uni-trust distributions are not discretionary, they're mandatory. And there are additional administrative tasks, such as valuing the trust assets each year, which might require an appraisal if there are hard to value assets. But keep this tool in your arsenal if you ever come across one of these non-grantor irrevocable income trusts. Thank you for your time.
Karen, thanks so very much. What a great organization you all are with. Real quickly, I want to bring up Drew Moser, who's part of our nonprofit spotlight. RJ Kelly, we thank you for thinking of this monthly spotlight. Drew is the Chief Executive Officer of Lucky Duck Foundation and was introduced to me by Glenn Arnold. Drew.
Thank you, Bill, and good morning. Thanks for having me here. So I think I've got 5 minutes to explain the Lucky Duck Foundation. It's really hard to be concise with who we are and what we do, but I will do my best. Our mission, no rush. Our mission is to prevent and alleviate the suffering of homelessness throughout San Diego County. We believe it's the most pressing issue throughout San Diego County, and so we work to apply business principles to help people in greatest need. People usually ask me, well, where does the name the Lucky Duck Foundation come from? Our co-founders, Pat and Stephanie Kilkenny, you can probably guess with a last name like Kilkenny, there's some Irish heritage, so luck of the Irish. And then Pat is an Oregon Duck through and through. He went to school at Oregon. He's a major benefactor there, and he actually went back to Eugene several years ago to serve as their athletic director and do some pretty powerful things with facilities and re-engaging some important donors, et cetera. So that's where the name comes from. And the premise is simple. If you consider yourself to have had some good luck and good fortune in your life, share that luck with others, share that luck with those in need. And Pat and Stephanie match all donations up to $1.5 million per year. So what is it that we do with those resources? Well, we invest them into tangible programs meant to have an immediate difference, programs that are cost effective and can come online very quickly. While government's focused on doing a lot of this and coming up with the most long-term expensive strategy possible, we're focused on the here and the now, and how can we help people move off the streets and find a better pathway that's totally humane, totally safe, but can be done at scale. These are bridge shelters that Lucky Duck Foundation has purchased and constructed, and we donate the use of those to the city and the county. Every night in San Diego County, there's 450 people that have a roof over their head in a bridge shelter that would not otherwise have a place to sleep were it not for our board of directors that got organized around homelessness 6 or 8 years ago and said, we need to do something to help. And the long and short version of bridge shelters is our group said to the city of San Diego, you need to do something here and we're going to help you, but we're not going to spin our wheels here. We need to get something done. And the late owner of the Padres, Peter Seidler, organized a group of business leaders in 2016, along with Dan Shea and our co-founders, Pat and Stephanie Kilkenny, to meet every single week to study the issue and determine what the private sector could do to influence change and to hold government accountable. And this was one of the very first things that came online shortly after they got organized. So these came online in 2017. For the next 3 years, unsheltered homelessness declined in San Diego County while it was doing a hockey stick throughout the rest of the state. Round numbers, these can come online for $10,000 per person per bed, while a lot of governments focused on adding or acquiring housing at $500,000 per housing unit, which takes years, if not decades, to accomplish. These can come online within months and help people very, very quickly. The next one. Food and Water is an outreach initiative designed that we underwrite the cost to provide cold, non-perishable meals to folks living on the streets to provide some sustenance and hydration, but really it's a way to build trust and rapport to help people move off the streets. So much of what we do is about collaborating with organizations. With this particular program, we partner with 20 to 30 different organizations who pick up the food from us, distribute it throughout the county to help people move off the streets. Go ahead and do the next one. Sleeping bag coats. These are winter coats that transform into sleeping bags that are made by formerly homeless parents who are employed full-time to manufacture them. Over the last 4 years, we've distributed over 12,000 coats as a way to provide some level of warmth and protection from the streets. And we do that while pushing on government to say, hey, can't you do better than this? We try to alleviate some suffering while calling on government to add more inclement weather shelter beds. There have been more than a handful of people that have moved off the streets into housing, gained employment full time, and have come back to us and said that coat literally saved my life. It would not be here were it not for that coat. We funded more than 25 different employment and job training programs designed to put money in people's pockets and get them employed right away or get them the training that they need. Give you 2 quick examples. This is Emiliano on the right. It's a partnership between the Salvation Army, Feeding San Diego, and Lucky Duck that hires shelter residents at the Salvation Army, trains them as food rescue route drivers. Feeding San Diego provides a vehicle and all the rescue routes, and then funding from Lucky Duck provides all the wages, plus the gas and the maintenance and the insurance to employ people like Emiliano, who's trying to put homelessness behind him. That program's rescued over 670,000 pounds of food, and just about every single person who's gone through that program has secured long-term employment, and they're still housed. Another example is Timmy's Place there on the left. It's a pizzeria and a print shop downtown that trains and employs homeless youth at a homeless youth center downtown. Cash for Trash pays people $2 for every bag of trash that they clean up from downtown. That's removed over 200 tons of trash just in downtown over the last 18 months or so. Again, it's hard to be concise. These are a few examples. The bottom line, we don't care about credit. We care about collaboration. We care about helping people here and the now while endeavoring to push on government to be more swift and practical in their approach. And if we can do the last slide. One way we do that is something called shamrocks and shipwrecks. It's a public scoring system meant to grade political will and effectiveness throughout San Diego County of elected leaders and their cities to address homelessness. It's all fact-based. We don't care if you're Democrat or Republican. We care about practical steps forward that can actually help people. Good actions get a shamrock. Those candidates should be replicated. Inaction, bad actions, bad decisions get shipwrecks. And candidly, it's meant to compel political will. So much of homelessness comes down to elected officials taking meaningful steps forward. If they do so, we'll be the first to pat them on the back and give them a shamrock. If the effort's not there, though, we're not afraid to make the pat on the back a little bit lower and harder. So again, there's way more to cover, but and there's some informational cards at your desk. Our co-founders care sincerely about helping people. They don't care about credit. They match all donations up to $1.5 million per year. And again, we invest that into programs that we own and operate ourselves, or through a number of strategic collaborations meant to go out and help people today as quickly as possible. So I probably went way over time, but thank you very much for your time, and happy to answer any questions.
Drew, thanks so very much. What a great organization. A lot of direct action going on. Certainly nice to hear. Without any further ado, and I will say we will go till 9:15. If you have to go, you have to go. But this presentation will be a great one with Rebecca O'Toole and Sarah Pike of Withers Bergman. They're going to be presenting on a new direction on California's directed trust legislation and their uses. Rebecca is a partner at Withers Bergman, an ACTEC fellow. She's the office managing director of the San Diego office. And many of you know her, but her bio has been in the meeting announcements. And without moving on to Sarah Pike, she's an associate at Withers Bergman, and I let you take it from here.
Thank you. Can you guys hear us? Okay, great. We had an event last night and wasn't so easy to use the microphone. I had to be much closer and to kind of eat it. So this is a much nicer arrangement. But we're happy to be here. Sarah and I are talking about directed trust today. We do a lot of directed trust work already. Even though this act was only brought into California this year, we commonly do our directed trust the way we've done in the past is in other states. We do a lot of work in Nevada, Wyoming, Delaware, South Dakota, and we have not done directed trust in California in any kind of meaningful way up until maybe starting now. Directed trust has been around for a long time. The first act came in Delaware in the 1980s. Starting in the early 2000s, other states kind of started adopting things too, and they've become very, very popular. There's a lot of reasons why they're popular, and we'll kind of get into that. But California had proposed back in 2010, the state bar had proposed to adopt a directed trust statute back then. It did not pass. And now finally it has come back in, although in a very different format than what was proposed initially in 2010. This act is not going to make California suddenly become the new Nevada or the new Wyoming. We are still California. We are going to do things much differently. We're not going to become the new trust statute state. But there are definitely uses that are going to be important and meaningful for people in California. And so we'll kind of talk about that. So our overall outline of what we're going to talk about is what is a directed trust and why did we need a statute here in California? And then we'll talk about the specific provisions of our statute and a little bit of comparison to the other jurisdictions that we've talked about, like Nevada and Delaware, kind of look at what are the differences. And then we'll finally talk about how we're actually probably going to use the statute here, how people in California will use the statute and what we'll see coming down the pipe. One more.
Okay, good morning, everybody. So as a kind of background, before we talk about directed trusts, let's talk about regular trusts. What is a unitary trust? A trust at its essence, as many of you probably know, is a fiduciary relationship between three parties. The settlors or grantors or trustors, that's the creator of the trust. Then you have the trustee, The trustee is a person who holds the assets for the benefit of the beneficiaries. You need these three parties in order to have a trust. So in a unitary trust structure, the trustee is the one managing the investments and making distributions to beneficiaries. Trusts can be revocable or irrevocable. Probably we're all most familiar with revocable trusts where the settlors and the trustees tend to be the same people, at least during their lifetime. But as people pass away, the trust flips to an irrevocable trust. They name a successor trustee who administers the trust and makes distributions to the beneficiaries. Okay, so importantly, so this presentation is going to talk a lot about what it means to be a trustee, what are the different roles in a directed trust of different people who direct the trustee in different ways. But just for background, being a trustee isn't easy. Show of hands, who's been a trustee of anything in this room? Okay, so these are your fiduciary duties. You have the duty of loyalty to administer the trust solely for the beneficiary's best interest, the duty of care, to be prudent with the investments, frugality, good faith, impartiality. If you're administering for, your brothers and sisters, you have to be fair and equal to them. The duty of prudence, administering the trust as a prudent person would. And, you're in charge of the trust property. You have a duty to account to the beneficiaries. You control it. You have to manage it well. So there's, it's a big ask. So I think there was a presentation in March about who should act as trustee here at North County. And so I won't go over that again, but it's a big question.
So, thinking about that, this is why the directed trust has become so popular, because it is a really big ask to ask one person or one organization to do all those things, right? So you might have a situation where, and this comes up, can we go to the next slide? Yeah. So these are the situations where we think, okay, why do we need something different than this unitary trust structure when you're in California? And so the first one is, a settlor might come to us and say, hey, I really think my sister would be great at deciding on how much my kid should get, but she's not going to be the person that can manage the money. I want somebody else entirely to manage the money. Or you might have a situation where you have a business owner who says, I really want my business partner to manage the trust with respect to the business, but I don't want that business partner deciding what my kids are going to get. I want some other person to decide on distributions. And then we have this whole series of trust protectors. And we've used those, we'll get into more about what a trust protector is, but we've used these for years in California without actually having reliance on a statute for what it actually means. But it's some person that you want to put in to, in a lot of ways, oversee the trustee, make sure the trustee is doing the job that you wanted them to do. And in California, we just didn't have a good statute on that. Okay, so next slide, there we go. So prior to this act coming in California, you could still do this stuff, right? So you could say, I'm going to create a special trusteeship. I'm going to create a directed trust, but you didn't have reliance on a statute telling you that you could do it. And so what does that mean? What it means is that a fiduciary who engaged in that type of trust was taking on liability. And the reason is because the law didn't exculpate somebody from their otherwise statutory mandated duties. So there's a few duties that a trustee has that you could not get out of before this law came in. So the first is the duty to oversee the acts of others, right? So when you take on a trusteeship and there's a co-trustee, whether you call that person before a special trustee or a directed trustee or whatever you called them, the law would have treated you as a co-trustee. And so if I said in my example before, okay, I'm going to have my sister be the one to make distribution decisions, and I'm going to have Bank of America be the one to make investment decisions, technically they were both co-trustees and they had a duty to oversee each other. So even though my document said, no, only sister decides what happens with distributions, Bank of America would say, well, actually, we have to oversee you and make sure that you're doing that correctly because we're liable if you don't do it correctly. And under the common law or the prior law before this act came in, there was very limited ability to delegate any of those duties to others without having to oversee them. So first of all, the law was you cannot delegate any duties that you could reasonably do yourself, except in the case of investment management. So there is this exception for investment management, so that a trustee could say, hey, I want to appoint Wells Fargo as the fiduciary to manage this account. But in doing that, the trustee who appointed Wells Fargo delegated that authority, still has the authority to use reasonable care and to oversee that investment management. You can't just completely get out of it. You're still on the hook for overseeing and making sure they're doing a good job. The other thing you couldn't get out of is that if one of your trustees, this person that you might think, well, I have a different job. They were the investment manager. I'm just the distribution advisor. Well, if one of those parties breaches their duties, you're on the hook for what they breached. And there was no ability under the prior law to limit that liability, right? You couldn't say, you couldn't get them out of gross negligence. You had to at least avoid gross negligence. So because of this, in the past, even though we could have done it, many fiduciaries would say, yeah, we're not doing that. But let's see, let's go to the next slide here. These are the specific, we kind of walk through these, but these are the actual code sections that are, and these are still valid law. These are still in the code. So if you don't opt into the directed trust statute, all this stuff still actually applies. And you have a duty not to delegate, a duty to oversee your co-trustee, and you have liability for the breach of your co-trustee. Let's skip to the next one too. Okay, so here's an example, and this is like a real example of clients that I've had, right? So John and Jane, of course, names hidden to protect the innocent. They own a successful car dealership, and they have several real estate investments and a large cash security portfolio. When they pass, they want their business partner. They want the CFO to continue running that business, and they want that business partner to be what we called back then, before we had this, a special trustee to continue running this. But they wanted a corporate trustee to serve as trustee for everything else, including making distributions to their kids. So here's the problem. This is something that we have to actually talk about with clients. Now, number one, you would say, well, why did you even do this, Rebecca? Well, because if it was an irrevocable trust, I would have moved it out of California and adopted into a jurisdiction that had directed trust statutes. But here, this is a revocable trust. They're still alive. They're living here. We're not going to move it into Nevada. They want to be the trustees themselves here. We're trying to provide for a structure for what happens initially on their incapacity. So we're kind of stuck in California for this situation. And so it comes down to just explaining the risk. And can we get someone to sign on to doing this, right? So they have to understand, if you pick a corporate trustee, the corporate trustee is going to say, hey, I'm nervous. So, and the special trustee is going to say, hey, I'm nervous too. How are we going to work together on this? And how are we going to manage our risk, right? If the corporate trustee mismanages the investment portfolio, this person who put in as a special trustee, who might think, I have no duty to oversee that at all. I'm only on here to manage the car dealership. Well, you're kind of on the hook. So they've got to kind of pay attention, or risk being liable later on if things go south. Same thing for the special trustees. So they're managing the car dealership. You might think, well, Bank of America or corporate trustees out of this. Well, they kind of have a little bit of a duty to oversee that, because if the special trustee mismanages that, corporate trustee is on the hook for it under the prior version of this law. And so that begs the question of, what level of communication do the trustee and the special trustee in the situation have between each other? How much do they have to talk to each other? How much information sharing? How much oversight is there? Under the prior law, I think it's pretty clear that even though we would try to set this up as bifurcation and distinguishing them, the case law would have treated them as co-trustees. And if one of them breached, they would have both been responsible for the breach. Okay, so all of that kind of gets us into, why do we need a directed trust statute? We needed something to make people, trustees, settlors in California, more comfortable that they could do this in a way that limited liability. The big issue, again, as we just talked about, is liability. And liability really equals cost, right? So when you have greater liability, inevitably, the person who's acting and taking on that liability is going to charge more. They should, because they could get sued. And they're gonna have to do more work because they don't know where their job ends. So the point of the directed trust statute is a lot of ways is to limit liability.
So this is the way that a directed trust kind of looks different from the unitary trust that we saw earlier. Here you see, still have the settlors on top, still have the trust, but instead of a unitary trustee, we have a directed trustee. And then we have these other roles: investment director, distribution director. The investment director is the one who would, act with regard to the trust investments, and the distribution director acts with regard to distributions to beneficiaries. The directed trustee keeps the administrative functions, could be, accounting, tax returns, day-to-day management. And importantly, the directed trustee is still the one who signs for everything. So when we kind of explain this to clients, one of the questions that comes up is, well, is it complicated? How do we manage all these people working together? And it's as simple usually as, the distribution advisor or director sends an email to the trustee and says, please distribute $10,000 to this beneficiary. And the trustee says, okay. And they do it. But
That's in California, but not in California, but we'll see how that goes.
Yeah.
But like in Nevada, that's how it works, because in Nevada, the trustee has zero responsibility. The directed trustee has zero responsibility to evaluate whether that request was reasonable or not. So it might be a little bit different.
in
Yeah, in
theoretically,
theory, that's how it works.
theoretically, this is how it works. And I think, who's signing on the bank accounts, that comes up a lot. It's always going to be the trustees. The administrative or directed trustee is the signatory on the accounts.
For that reason, in a traditional directed trust format, because you always have to have this directed trustee signing off on everything. Oftentimes what we'll do, and by the way, I should mention too, so you don't have to have both of those. You could have just an investment advisor or just a distribution advisor, and whatever role is not filled, the trustee just assumes that role. So you could, a lot of times we'll do it where we have the directed trustee is in fact the investment director too. And it's just, you have a separate distribution director coming in to just advise on distributions. But because of this need to always be involving, and it is in the situation, the directed trustee that signs off on everything. So that means every time you buy a stock, to buy a piece of real estate, you need the directed trustee to sign on everything. And so sometimes it's easier. What we do a lot of times in Nevada is we'll drop all the assets into a separate LLC below the trust and put that investment advisor, whoever we pick as the investment director, investment advisor, on as the manager, so that they can just sign everything without needing to involve the directed trustee every single day. And then you really only in that situation would need the directed trustee to sign on something if you're making a distribution, right? So you send money back up out of the LLC to the trust, and then the trustee is directed to sign off on the distribution.
Yeah, so you can see here the functions of the trustee, the duties of the trustee are unbundled. Okay. So why do people like these? So directed trusts, as Rebecca mentioned, are very popular. 47 states have some kind of directed trust legislation. I think California is the most recent adopter of directed trusts. So fiduciaries really like the directed trust structure, corporate fiduciaries. I think with corporate fiduciaries, what they deal with is risk management. They are very concerned about taking on risky investments, consolidated stock positions, concentrated positions, privately held companies. As if a corporate trustee takes over in someone's revocable trust after it becomes irrevocable, they're going to look at the asset portfolio and think, okay, well, do we need to sell? Do we need to diversify? They have a different perspective on diversification than individual fiduciaries do. So they like directed trust because they get to hold things and be directed by an investment director. Please don't sell the family business. I'm directing you to retain it.
The other reason I think why they like it too is that, so a lot of banks and brokerage companies have set up their their trust company. And the reason why they set those up for the most part is to retain the business, right? They just don't want some other trustee coming in and using their own investment advisor. And oftentimes the family wants to keep their investment advisor too. And so these are set up as a way to retain the business. And as an added thing, okay, great, now we have to actually act as trustee, and that's a whole bunch of liability. What if we could do this in a way where we can stay on as investment advisor, but have someone else take on the liability for making the trust distributions? That sounds like a good deal. So trustees, corporate trustees do like the whole directed trust statute, and they've in many different jurisdictions, and they've really become popular. So I would say, I mean, at this point, probably 95% of the irrevocable trusts that I'm drafting are directed trusts. It's very rare that I'm drafting something that isn't a directed trust.
And that, I mean, for irrevocable trusts, that often is because the grantors aren't allowed to hold certain powers. So having, or if you're doing trusts out of state, you need to get situs in the state. And we'll touch on that a bit later. But in terms of why would a grantor want a directed trust? So again, they can fund it with non-traditional assets and still use a corporate trustee. They can have their small business, private company funded into the trust. They can appoint a friend or a trusted advisor or a longtime investment manager if that person consents to act as investment advisor or investment director, but have a family member or maybe a committee of family members deciding on the distributions. So,
And importantly, that the real
yeah.
kind of key for families in this is because of this ability to reduce the liability on the corporate trustee, it results in a much lower fee. Now, we'll talk about this, whether that's going to result in a lower fee here, but in a place like Nevada, where you can completely eliminate the liability for the trustee, they really just sit there and just take direction, and they have no liability for evaluating whether that direction is good or bad. They just do it, and that's it. When you can do that, you can do this really cheaply because you're just taking the cost of what does it cost for us to provide that service? We have zero liability. So we'll find trust companies in Nevada that will charge $3,000 a year to serve as a directed trustee. That's really cheap compared to the traditional model, which is typically a percentage of the assets under management, which are looking at maybe 1% of things that they're not actually oftentimes even doing anything with, right? If you have corporate real estate, they're just sitting there, they're not actively managing it. Maybe it's an LLC, but they're charging a percentage because they have to, because there's a liability. If they do something wrong, they're going to get sued. They have to charge the fee. In this case, you can charge the trustees can charge a much, much lower fee, and clients really, really like that.
So this just shows the roles. The two that we're talking about mostly today are on the top: distribution director and investment director. So as we've kind of mentioned, it doesn't have to be a single person. It can be a committee. And sometimes this can blend a personal or family relationship acting in some fiduciary role with a corporate trustee acting in the role of, doing all the accounting and administration and things that can be difficult for family members to do. So that's distribution director. Investment director can also be called investment advisor, or it can also be a committee. And these are the people who direct the trustee for, with regard to the trust assets. We also have the trust protector. Trust protector is a slightly different role. I think historically a trust protector has acted more as an agent of the settlors when the settlors can't, for tax reasons, exercise certain powers over the trust. They can appoint a trust protector to do so. Trust protector in California has always been, so California considers most trust advisors fiduciaries. Other states do not. Other states allow trust protectors to be considered non-fiduciaries. So the California statute does address carve-outs in which the trust protector can act in a non-fiduciary capacity, even in California. So that's kind of a new thing in this statute. And then the directed trustee does the administrative record keeping, accounting, and tax filings.
And I will say too, it's, these roles are it's always been a hard thing to think about for a client. How do I pick a trustee? What's the right thing? Is it a person? Is it a corporation? This doesn't get any easier in this context. You still have that same kind of consideration. Who am I going to pick? Who's the right person for this? And oftentimes with the directed trust too, we have this additional layer of, okay, typically we want this to be a non-California person if we're doing this outside of California. And it's a tricky thing. Like we have a client who she put her dad in as the distribution advisor and investment advisor, and then a whole deal was going down and he's on a cruise in Antarctica. We're like, crap, how are we going to get him to, he's got to direct the trustee and he's in Antarctica. So it gets tricky to find who is that right person. It doesn't make it easier.
Yes, I also think it'll be interesting. I mean, the statute's fairly new, but in California, whether financial advisors will be able to act in this role as an investment director. A lot of bigger companies or banks won't actually allow their advisors to be named in documents. So I think that's something that is, likely still getting worked out, but it'll be interesting, and it's worth talking to clients about if they think, oh no, I'm going to name my financial advisor in this role. Just, make sure that that's actually permissible, because in my experience, it often is not. They will say no. Okay, we'll go to the next slide. Okay, so the California statute, I think the impetus behind it, both in, since 2010, 2011, when it's first started getting legislative traction, is to figure out the best relationship between, for liability purposes, between someone who directs the trustee and the liability of the trustee. So there's a few approaches. Rebecca kind of touched on number one, the common law approach. The common law would treat a trustee and a special trustee as co-trustees, or they would treat it as like a delegation of power, meaning that it's still joint and several liability. The trustee takes all the responsibility for the actions of its co-trustee. Then we have some kind of pendulum swinging approaches. On one side is the no duty approach, where a trustee is completely exonerated from any liability. This exists right now in some very popular trust jurisdictions, including Alaska, New Hampshire, South Dakota, Wyoming, and to some extent Nevada falls in this category. This, I think it's a little bit of a race to the bottom with states vying for trust business. And, we ended up with this kind of murky, like the trustee can really take no liability for acts of the trust directors in those states. That's great, but what happens to beneficiaries is the question that I ask. I mean, if it's complete exoneration for the trustee who's a directed trustee, you have to give a lot of care to who are your investment and distribution advisors. Okay. Other side of the pendulum, duty to monitor. This is where the directed trustee has to watch out for what the trust directors are doing. So in this one, there's a duty to monitor. Originally, this was followed in 20 states. Some of those states have now flipped to the more modern approach, which is what California has. But the duty to monitor basically is that if a trustee knows it would breach a fiduciary duty to act on a direction that they're given, the trustee should not take that direction. So it involves some judgment and some monitoring of the trust directors. Then we have the Uniform Act, which is now followed in 17 states, including California. And this basically has, they call it, because lawyers love these words, a scintilla, a scintilla standard, which is like a minimum standard of conduct to avoid willful misconduct. So it permits exoneration of the trustee, except to the extent that the trustee engages in willful misconduct if it complies with the direction of the trust director. So, if the trust director says, sell all of my Coca-Cola stock and buy NFTs, because I'm really into NFTs, does the trustee follow that direction? If they don't, How do they judge? Is it willful misconduct if they follow that direction?
And that's the big question. That's why this is going to be hard to administer. It's much easier in a place where you can say, I don't care. I don't have to think, when you're thinking about the liability of this, right? And the cost of how you're going to price the services for this. If you can literally say, I don't care. They told me to sell Coca-Cola and to buy NFTs. I'm doing it. It doesn't matter whether it's reasonable, doesn't matter whether it's good. I'm just doing it. That's not the standard we have in California. So we have a little bit different thing. But okay, so starting January 1 of this year came the California Directed Trust Act statute. And it will apply to any trust that has a principal place of administration in California. And the way the statute is written, and this is different than some other statutes, it doesn't define exactly what all these things that we're talking about are. It doesn't say, this is what a distribution director does. This is what an investment director does. It just allows the trust to incorporate these things and provides a mechanism for exonerating or limiting liability, depending on the roles that you're assigning. So this is leaving a lot of work for the attorneys to draft this stuff to make sure that we're doing it correctly. Because in some places, like, for example, Delaware, it will define a lot of these terms. So when I do a Delaware trust and I send it out to be reviewed, we're so used to having to write these out. But Delaware will say, can you please put the reference to the code section too? We want to have the exact, because it's already in the code. We want to have the reference, the exact definition in the code section. We're not going to have that ability in California. We've got to have very careful drafting about what the powers are, and carving out the powers between what the trustee does, what the investment advisor does, what the distribution advisor does. What happens if there's a vacancy in one of those roles? When does the trustee have the ability to act and pick up those powers?
There is commentary to the Uniform Act in California that has a kind of laundry list that describes the roles of each of the directors, but it's not part of the statute. So
Yes. Yep. So, which I kind of like that better. I like that we have the flexibility to define what we want it to be, rather than having to, sometimes you see when these acts are put in, there's so much negotiation and like trading that goes on in the background that you don't always love exactly the language that ends up in the statute anyway. So I'm happier with this. But. Okay, so there's a couple key points. I would say, let's see, we have 3 key points about the California statute. Okay, the first is fiduciary. Who is a fiduciary? In a place like Nevada, I can literally say in my document, okay, the trustee is directed and has no liability for following what the investment advisor and the distribution advisor say. And I have the ability also to somewhat limit even the liability of those investment advisor and distribution advisor. South Dakota is even further. You can like completely have nobody has any liability for anything. There's no fiduciary liability around the block. But for California, what California law says is, okay, if you're going to take the liability off of the trustee, somebody else has to pick it up. Like somebody here has to have liability somewhere. And so it's imposing a duty that the distribution advisor and investment advisor are going to assume that fiduciary liability to the beneficiaries. If the trustee doesn't have it, someone else does. So there are a couple limited exceptions where we can remove the fiduciary status. And for the most part, it's not that the reason why Sarah and I care about fiduciary, whether someone's a fiduciary or not, really isn't about California Directed Trust Act. It's about California income taxation. So when I'm looking at this, I'm typically when I'm doing a directed trust, I'm trying to keep it out of California. I want it to not be a California taxpayer. And if I put any person on in any one of these roles that is a California person and they're a fiduciary, now I've suddenly brought this trust back into California. So the one limited exception that we have for these roles that will apply here, I mean, some of these apply to beneficiaries and trustee and the settlors, but the power to appoint and remove the trustee. So if all you do is have a trust protector and their only power is to remove and replace the trustee, that I think you can still say is a non-fiduciary role. And if you give somebody in California that role, it will not cause the trust to come back into California. Anything else, you give that trust protector and you put a California person in, they are a fiduciary. As a fiduciary, will pull the trust back into California. So before that was kind of unclear in our law. I think we had many discussions for years about, come on, we think these are, that's how it's going to come down. It is a fiduciary. But now it's clear. Now we know it will be considered a fiduciary. Okay, next one is, and Sarah was talking about this, the duty to comply with the trust director's directions. And so the director trustee is required to take reasonable steps to comply with the direction of the trust director, unless complying with the direction, the trustee would engage in willful misconduct. Now, willful misconduct is not defined in the statute, so that's going to be a fun one. It presumably kind of relates back because it is defined in the Delaware statute, although interestingly, Delaware spells it differently, which I don't know if that's just a spelling mistake or if it's intended to be a different word, but they spell it with one L, we spell it with two L's, which whenever I send trusts out to Delaware, they point that out and I'm like, fine, I'll use your stupid spelling, it's wrong, but so we don't actually know how it's going to be interpreted. So in Sarah's example of, okay, sell all the Coca-Cola stock. And what if it's even like it's sell all Coca-Cola and buy cryptocurrency that I really think is going to disappear the next day? What does the trustee do? Like, what is willful misconduct for them to act? And so conveniently, there is a provision because, California loves to have reasons to go to court, apparently. But the director trustee, if they have doubt about whether they can follow that advice, is allowed to go to court, petition the court, and seek the court's advice about whether it would be willful misconduct to engage in that or follow that direction.
And I do think that corporate trustees using the California statute will end up petitioning the court a lot for instructions, which is not an overnight process. So if it's really an investment decision that's questionable, but it's something that has to be done quickly, I think that'll be very difficult to actually have it happen.
Yeah, for this reason, I mean, we haven't done a survey. We thought about this. Should we talk to California trustees and see if they're even thinking about changing their pricing and offering some directed trust model? I just don't think it's going to change the pricing significantly, maybe a little bit, but not significantly for California trustees acting as directed trustee because they still have all this stuff to think about, right? They can't just act blindly. They have to still consider, is it a good advice? Okay, so the other things that are part of this are certain other duties to monitor and inform. So there is some of this, right? There is that the ability in the statute to alleviate the responsibilities to monitor each other, right? So a directed trustee does not have to monitor what the trust director is doing and vice versa. And that you can't, the other part, what we talked before in my earlier example of like, oh, I wanted co-trustees and I want one to be distribution advisor, one to be investment advisor. You can do that now, right? So you can actually have the extension to co-trustees that extends so they don't have to monitor each other to the same way they were doing before, where they're not liable for each other's breaches, which is great. But again, like somebody at the end of the day has to be fiduciary liable in California. And so they also, and this is different than other states, and Sarah will go through a kind of a comparison of other states, but the duty to communicate here, the trustees and the director trustee and the directors do have a duty to share information back and forth with each other, which is different than other states, to the extent that that information would be useful and reliable and needed for the other person to make a decision about whether that act is willful misconduct, for example. Yeah.
Okay, so now,
Oh, let me add one more point too. Going back to this, like, so I just talked about how the trustee doesn't have the duty to, give him to monitor what the trust directors are doing. But the trustee does still have its own duties to beneficiaries that are in. So if the document, for example, says the trustee has to account to beneficiaries, the trustee still has to do that, even though it's directed. It still has to actually follow its own duties to beneficiaries in the document.
so with we chose just Nevada and Delaware to do kind of a comparison of the key differences. Of course, Nevada falls more into the no duty category. Delaware is pretty similar to California, except for how they spell willful misconduct, and some very academic debate about there's like a slight nuance difference in the liability standard. But so key differences. First, fiduciary status. So California, the statute says the trust directors are fiduciaries. Not every state requires this. Most states have as a default that a trust director is a fiduciary, but you can actually put it in the trust document to opt out of fiduciary status. For example, Delaware and Nevada, the trust agreement can provide that they're not a fiduciary, and that kind of overrides the default rule. California would not permit this. If you have people acting in these roles in California, they're going to be acting in the best interest of the beneficiaries, bound to the same standard as the trustee.
I'll tell you that too, on that point. Yeah, even though that's allowed in places like Delaware to say the trust director is not a fiduciary, corporate trustees do not like that. They want someone else on the hook, right? Because if there's no one on the hook, the person with the big, or the entity with the biggest pockets is the one that someone's going to try to come back against. So they are always pushing, even though I'll point out and say they don't have to be a fiduciary. Oh, but we want them to be a fiduciary if they're going to take that role, otherwise we're not going to do it.
Yeah. So the other big point of divergence is what we were just talking about. What's the relationship between the trustee and following directions in terms of who's on the hook if something goes wrong? What's the liability? So in California, it permits exoneration except to the extent that by complying with the direction, the trustee would engage in willful misconduct. So the focus for California is actually on following the direction, not the behavior of the trustee. As we discussed, this will probably result in more petitions for instruction to the court about, is it willful? Does it rise to the level of willful misconduct if I do X, if I sign X that I was directed to sign by the investment director?
Yeah, essentially, it's imposing a duty to monitor and evaluate whether the direction is reasonable. Maybe not reasonable is not the right word. Whether it would be, it's a much higher standard than that. It's not just reasonable. It's would it be willful? Would it be really, really bad?
Yeah.
Right. If I did that, so is it a
might
breach?
It might be easier to think about it in terms of a distribution. So let's say a trust has $1 million and the distribution director, and it's a pot trust for 3 beneficiaries. And the trust provides that distributions can be made, don't have to be equal to all beneficiaries. But then the distribution director comes and says, okay, I want to give $900,999 to one beneficiary. So is that willful misconduct if the trustee just follows that direction and empties the trust?
Especially what if the distribution director is also the beneficiary who's receiving that, right? Like
That's an
now
easier
what do you
case.
do? That's an easier. Nevada would say, we don't care.
Yeah.
We don't have to evaluate that. Here, I think there's some duty to
Yeah.
evaluate that.
I think the corporate trustee would be very reluctant to follow that direction.
Yeah.
And so, but in Nevada and Delaware, in Nevada, they would basically be completely exonerated from liability. And in Delaware, kind of the same standard as California, except Delaware, there isn't this associative misconduct. So Delaware, it's the actual trustee who has to do the willful misconduct, not just evaluate if the direction is going to be regarded as willful misconduct.
I think it's kind of like if the trust director directed the trustee to make a bribe to a foreign government, like with the payment of that actual bribe, that's a breach, it's misconduct. They don't have to think about whether the underlying action is bad to the beneficiaries or the trustee. They have to think about my actual act. Is that a bad act that I would be doing? So it's much lower level of liability in Delaware than here.
Okay, so now we're coming back to California. We're spending time talking about other states just because that's mostly when we'll use directed trusts, I think, even after California's act. But I think there are some interesting California uses.
Yeah, so, okay, so why do we love other states? Okay. So there's so many reasons why we opt. I mean, it's very rare that I'm drafting an irrevocable trust in California. I'm drafting revocable trusts, and sometimes I'm drafting irrevocable trusts, but always with the idea that they could be moved later on to another state. And the reasons for this is, number one, we've got better rule against perpetuities provisions, which just means the trust can stay in longer and be a dynasty trust for generations. Now, of course, I kind of think that's a little bit theoretical because you've heard that whole thing about short sleeves in 3 generations. So it doesn't usually last more than 3 generations, but people like the idea that it could. And we can't do that here in California. Other states also have really great creditor protection laws that we don't have here. And they have virtual representation, which means that you can have somebody, you don't have to have the extensive court proceedings that we have here and involve every beneficiary and have a guardian ad litem. You can do that. You can do away with that stuff in other states. Much easier to administer. You can also keep things silent. You don't have to tell anybody that the trust exists for many, many years, depending on the state, how long you can keep it silent for. Here, there's an affirmative duty the minute the trust is created to tell the beneficiary that it exists and start accounting them and reporting to them. There's also, we do a ton of decanting, and I know that that's a recent act that came in too for California, which is not the greatest. The California Decanting Act, I think, is kind of useless. We still will move the trust to another state and use the Nevada or the South Dakota Decanting Act because it's just so much easier to use, so much more user-friendly, so much better for the trustee to decant under those statutes. So the main ones that we're using all the time are Nevada, Delaware, Wyoming, South Dakota, I think are kind of our top hit list. And others, I'm sure New Hampshire, for people that live on the East Coast, is a big, I think people, it's kind of it doesn't really matter, honestly, what state you use. But for some reason, for California people, it feels better to be closer to your trustee, right? So you're just the next state over. Texas is another big one too. So, your proximity wise, you're kind of close and it feels comforting, I guess. And so once we make that decision to say, okay, there's all these reasons why we have to go out of state because it's just better. Then we're like, well, okay, we're going to hire a corporate trustee because you need to have nexus. You have to have a reason, a way to get into these other states. And so you've got to hire somebody. And if you go out and hire a corporate trustee to serve as that unitary trust model, it's not cheap. It's pretty expensive to serve as a unitary sole trustee. And the directed trust model has enabled it to be so cheap. $3,000 a year. You can have a Nevada trust, slightest out there, easy peasy, cheap.
Lasts a long time.
Yeah.
So it's not every client who wants to deal with the hassle of an out-of-state trust because it is more complex. You need a in-state trustee, which is usually a corporate trustee, unless they happen to have a best friend in Nevada who wants to be trustee of their irrevocable trust. But when we're creating these now, it's usually to make gifts for descendants. So irrevocable trusts that are out of state can last a long time. The goal is to have, make a gift right now with the historically high exemption amounts, get it out of the grantor's estates, and then just leave it there and have it grow and grow for future generations. And
so the big kind of layer on top of this for why all those reasons are great. But the real big one that often comes up is that people say, I don't want to have to pay California income tax if I don't have to. And so you have the ability to move a trust, make it a non-grantor trust in one of these states that don't have state income tax. And thereby, as long as money isn't coming back into California, you don't have income, you don't coming back to California beneficiaries. If you don't have real estate in California, then you can avoid the California tax. So for example, if I have a client who's making a gift to little babies, and there's this child is not going to need this money for 25, 30 years, why subject that to California tax for those 25 years before the child actually needs the money? If we put it in Nevada, it can sit there and grow and not have to pay California tax. The money's not coming into California. So why would we need to pay the tax here? So there's a lot of income tax reasons why we do it. But there are certain times where we don't care about the income tax, right? So if that is my example of the money's coming back into California, so the California beneficiaries here and they're using all the income, well, we're going to be taxed in California anyway, so we might as well be a California trust. We don't need to pay a trust company in Nevada when we're not getting the benefit of being a Nevada trust. Also, we have these things called grantor trusts, which I don't know if people know much about those, but it's basically where the grantor of the trust is treated as the income tax owner of the trust. We use those a lot in planning. They're very, very powerful, but the result of it is that all the income comes back to the grantor. If the grantor is a California person, you're going to pay California tax anyways. So maybe in that situation, you don't care so much about whether you're Nevada, Wyoming, or California trust. So why do we think, who's going to use this? That's the key. Like, who's going to use this California Directed Trust Act? So we've been thinking about this. Okay, so potentially, this is very potentially, there might be lower corporate trustee fees for California trustees that are acting as directed trust, which might encourage some beneficiaries or settlors to say, yeah, we want to have the trust be in California. I don't know. That one's the least likely in my book.
TBD.
Yeah. But here's where it's really going to come up is, okay, so when I have it's really going to be more revocable trust planning, or that situation where it's an irrevocable trust where I just don't care about whether it's in Nevada. So it's a grantor trust, or all the income's going to be in California anyways, the beneficiaries, all the income, I don't care about another state. And so in that situation, it's really great that I can now plan for concentrated positions. I can plan for, if I have a family, my situation early on, the family that has the car dealership business, it says, hey, I really want my CFO to run the business. Great, we can do that now really easily. I'm going to amend that trust and make it perfect under the statute, right? We don't have to worry about this liability issue that we had before of like who actually takes on liability. It's clear we're going to do that. If I have a situation where I have a client, this comes up a lot where clients say, I really want a corporate trustee. I love what a corporate trustee does. I love the security of knowing that the money is going to be managed well and no one's going to run away with it and abscond with it. But they don't know my kids. They don't know anything about my kids. I would rather have my sister make those decisions. Great, we can do that now. We can help you. Your sister can make the decisions and the corporate trustee can manage the money. It's all coming back into California anyway, so we have no reason to move it out of state. Great, we can do that here in California now, which is really cool. Also, we do a ton, I think most of our documents have a trust protector because it's just such a, if you're thinking about these trusts that might last for, 200 years, you need to build in flexibility for what that looks like in 100 years. And the trust protector is the key to that, being able to evolve and adapt and change the document as things come along. And before, we didn't have as clear guidance on how that worked and what their liability was and their protections. And now we do. So that's a really cool thing. So talking about trust protectors, like we use these all the time. And so again, when we're thinking about this, the only one that you can exclude as not being a fiduciary is the only power that the protector has is the power to remove and replace the trustee. Fine, you cannot be a fiduciary. But for everything else, I think you're going to end up being a fiduciary. And so the common ones we use are the ability to amend the trust. So I'll often put, if I start here in California, I'll give the protector the ability to move the trust and to adapt it to become a directed trust in a different state. We often give the protector the power to remove and replace the powers that make a trust a grantor trust, the power to remove and add beneficiaries. Oftentimes we give them the power to grant a general power of appointment, which would cause the estate to come back in through the beneficiary's estate. It's an income tax thing, changing situs, moving it to another state. Also, this is a big one, I think, is overseeing the trustee. And oftentimes, after the grantor has died, approving the trustee compensation. A lot of the grantors say, I really like the bank today, and I love what they're doing, but I want to make sure there's someone who's acting as me that oversees that corporate trustee and make sure they're not going to go in rogue and start charging crazy fees. And oftentimes too, the ability just to terminate the trust. If it doesn't make sense to have the trust anymore, giving someone the ability down the road who can actually just turn it off. Okay, so what does everyone in this room need to do? What
do we need to do? This is the important takeaway is probably maybe the most valuable for everyone here is going forward, thinking about this new statute. Definitely from our perspective, we'll be, updating our trust documents, making sure that when we do California revocable trusts, we add provisions to allow the grantors to appoint these directors, if not now, in the future. And again, being specific about the duties in the trust document. Also talking about it with clients, saying, a client comes with a small business. What's your goal for the business after you pass away? Is there someone that you want to manage it? Is it your kids? Is it somebody else? You know, just kind of having those conversations.
Yeah, and for those situations where you might have had this kind of quasi directed trust thing, like I'm talking about before, going back to those clients and saying, hey, listen, we've got a new thing that can really help your situation. We should talk about amending your trust to opt into this. And then for the investment managers and trustees, or the trustees, I mean, I get that you guys have we should have had a longer section on what you have to think about, but I don't know what you're going to do with this. I don't know if you're going to reduce your fees and adopt into this or how you're going to manage it, but it's a more complicated thing. But I guess for the investment managers, it's just for you guys to know that it exists and be able to be talking to clients about it for when they, I think a lot of investment managers already know about the options in other states. But oftentimes clients are reluctant, or I shouldn't say often, sometimes clients are reluctant to adopt a trust in another state. That just feels weird to move a trust. And so for a client that really wants a trust to be in California, to know now that they have this ability to appoint the corporate trustee and still have family members involved is a good thing. I think that's important to be able to share with your clients.
Right. So that's what we have to say about the new California Uniform Directed Trust Act. And that's all there was.
Any questions?
Yes. Yeah, so, I think every attorney, when you're talking about this with clients, has a different approach to how you explain this. But I kind of start with, what is the goal you're trying to achieve, right? So what do you want to do? Who do you want to serve in these roles? Tell me your ideal situation. And then I'm going to help you structure it in the best way possible. So, if someone says to me, God, I really love my sister to be in this role, but I don't think she's right for the whole thing, I'm going to start talking to them about, okay, well, we have this directed trust statute. We could absolutely make that work. Sometimes clients say, I don't want anyone related in this thing. I don't care. I want it to be a bank. I do not care. They're not going to be the person I'm going to talk to about a directed trust. So really, I start with, what do you want? What are your goals? What do you see happening during your lifetime and after your lifetime? And let me help you fit in with what the available framework is to meet those goals. Exactly. Because you're right. If I just give this presentation to a client, their eyes will roll over and they'll leave. Yeah.
One is liability insurance available for the directed trustee?
So yes, I mean, and liabilities or insurance is already available in the unitary trust model. Those policies are kind of limited, because what they typically don't include is willful misconduct, right? Like you cannot insure against doing bad things. You can insure against the accidents. So I don't know if there's going to be some new policies that come out that do cover willful misconduct, but in the traditional policies do not cover those kind of bad acts. So we'll see. I mean, I suspect there'll be more policy coverage for the investment advisor, distribution advisor roles, right? Because those are kind of assuming the traditional liability of a trustee.
And the second question on Zoom is, must a California revocable trust be amended to allow directed trustee provisions, or does the law allow it by default?
So I think that the way the law is written is that it applies automatically to all documents that are California based, even before the law was created. But I think you're probably going to want to amend that anyways to be more specific. I mean, I think if push came to shove, yes, it's going to apply. Like in my situation that I talked about before, where I've got this special trustee relationship and I'm carving out duties for them that are different from the trustee. Yeah, I think it probably, the California law saved me, but I'm not going to rely on that. I want to go back and be very specific and rely on code sections and make sure that I'm under this law. But it probably already gets me there.
I think it would, but again, you know, your existing trust probably won't include the powers of the people who would be acting in these roles. So you could appoint someone as an investment director but where does it say, unless you amend the trust or restate the trust, where does it say what they do? Can they guarantee loans? Can they encumber trust property? I mean, there's
Yeah.
some specific things that I think need to be in writing and clearly set out.
Yes?
How do you think this will affect irrevocable life insurance trusts where oftentimes a family member is used because they consider the amount of work early on during the lives of the grantors is low? Will it change the way you're drafting those?
You know, it might. And that's a good situation where the trustee actually doesn't have that much liability because there's really not much to do in an insurance trust. And so that might be the one situation where a corporate trustee could say, hey, we'll do the back office stuff on this. We will agree to, send the crummy notices and do it for cheap as long as there's someone else that's on the hook for directing distributions, which we know aren't going to happen anyways. So yeah, maybe that might be the one situation where California directed trustee would be a cheaper fee.
Yeah. We'll add it to the presentation. No. Good question.
Good and advice of proposed action be used to protect directed trustee.
The statute doesn't say it can. The statute says you can petition for instructions, but we know the notice of proposed action process is, established and recognized. So I think I'm not sure.
Yeah, I'm not sure about that either, but it's a good question. I suspect it probably can, but it might be one of those things where we need to get like a legislative amendment to that to make sure that that you can do that.
I don't know if I'd rely on that entirely if I were a corporate trustee, but I think for maybe small amounts, things that don't create a ton of risk, I think that could be like an easier, faster solution than petitioning for instructions.
Yeah.
Well, thank you all so much. Just a reminder, our June 4th meeting, always Thursday, 4 to 7. You'll be getting an email shortly just on signing up and dealing with that, and hope you can attend. It's always a fun one. It's at the Urban in One Paseo. So we'll see you then.